we have already dealt with the International Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, the main treaty on women's rights. Nevertheless, CEDAW does not cover violence against women, verbal or physical, including rape. In 1994, in the Brazilian city of Belém do Pará, the American Community of Nations signed a convention dealing with this question. In this class, we will mention first the political and legal precedents of this convention. Then, we will analyze its most important sections. Finally, we will refer to the state of compliance of the states of the Americas. As early as 1928, an Inter-American Commission of Women was created. This organ was envisaged as a political body charged with preparing the necessary information for American states to regulate the status of women through international legal instruments. As a result, in 1948, American states signed 2 conventions on the political and civil rights of women, whereas the Commission was enshrined as a permanent body of the newly born Organization of American States, or OAS. A regional instrument on the pervasive phenomenon of violence against women was lacking. Although the inter-American momentum for the protection of the rights of women became somewhat stagnant during the Cold War, notably vis-à-vis the international efforts that gave rise to CEDAW in 1979, in 1990, the Inter-American Commission of Women drafted a declaration on the eradication of violence against women, which was followed by a similar OAS declaration in 1991. By 1992, the Commission had prepared a draft convention for the fight against gender violence, eventually becoming the text of the Belém do Pará Convention. On June 9, 1994, the Inter-American Convention on the Prevention, Punishment and Eradication of Violence Against Women was signed in Belém do Pará. It has been ratified as of 2016 by all 34 OAS states, except the United States and Canada. The convention entered into force in 1995. This treaty has 5 chapters. In its preamble, it affirms that violence against women is a violation of human rights, pervading every sector of society regardless of class, race or ethnic group, income, culture, level of education, age or religion. Chapter 1 of the Convention contains 2 of its most important provisions. Article 1 defines the terms violence against women as any act or conduct based on gender which causes death or physical, sexual or psychological harm or suffering to women, whether in the public or the private sphere. Article 2 further develops this notion by including situations such as rape, sexual abuse, battery, trafficking in persons, forced prostitution, and sexual harassment that occur within the family or in different interpersonal relations, as well as within a community, in the workplace, educational or health institutions, or in any other place. This broad notion of violence also comprises acts perpetrated or condoned by the state or its agents. Thus, it is said in the literature that this convention brought about a real change of paradigm regarding human rights protection, whereby not only the state is seen as a potential violator of such rights in the public sphere, but also individuals hiding behind the aegis of the private domain. Chapter 2 of the Convention sets forth the human rights enjoyed by women, including the rights to life, physical, mental, and moral integrity, personal liberty and security, the dignity and protection of the family, the equal protection before the law, the right to a legal recourse, to associate freely, to profess a religion and beliefs, and to access public service and take part in the conduction of public affairs. Article 6 further stresses the right of women to be free from all forms of discrimination and to be valued free of stereotypes. Chapter 3 of the Convention imposes specific duties upon states to ensure protection of the rights of women. State parties undertake the duties to refrain from violence against women, to prevent, investigate, and punish acts of violence against women, and to adopt legal and administrative measures and mechanisms to eradicate and effectively protect the right of women to be free from violence. Further, Article 8 imposes upon states the obligations to progressively adopt specific measures aimed at promoting awareness of the rights of women, modifying deleterious social and cultural patterns, educating and training public officials, providing specialized services for female victims of violence, encouraging the media to contribute to raising awareness on violence against women, information gathering, and securing international cooperation. Chapter 4 refers to the reports of compliance with the Convention that states must submit to the aforementioned Inter-American Commission of Women. Also, the states parties and the Commission may request of the Inter-American Court of Human Rights advisory opinions on the interpretation of the Convention. Indeed, this court has applied the Convention in key rulings such as those issued on the Penal Miguel Castro case of 2006, characterizing sexual violence in Peru as torture, or on the Campo Algodonero case of 2009, regarding structural violence against women in Mexico. Moreover, any person or NGO may file petitions to the Inter-American Commission on Human Rights regarding alleged violations of the duties of state parties to the Convention, as happened in the Maria da Peña versus Brazil case in 2001. Finally, Chapter 5 deals with general provisions, including 2 pro-women interpretive provisions, as well as limitations on the reservations allowed to states considering the object and purpose of the treaty. The ostensible inter-American eagerness to protect human rights means little if states do not comply with their international commitments. Hence, the importance of compliance mechanisms. In October 2004, the states parties created the follow-up mechanism to the Belém do Pará Convention, an agency charged with monitoring compliance with the Convention at a continental level. The follow-up mechanism comprises 2 main bodies. First, the Conference of State Parties, the political body which studies the country reports submitted by each state party and supervises the second body. And second, the Committee of Experts, the technical body composed of specialists appointed by state parties and serving in a personal capacity, charged with presenting recommendations and guidelines to the conference. Although there have been serious public policy efforts undertaken by states, in its second hemispheric report of 2012, the follow-up mechanism identified several challenges still to be addressed. Regarding legislation, the mechanism recommends states to criminalize trafficking in persons, forced prostitution, sexual harassment, sexual violence, femicide, and obstetric violence. It also recommends legalizing therapeutic abortion and abortion after rape. The mechanism also recommends training authorities and decision-makers in the contents of the Convention, as well as increasing participation of women in civil society and cooperation by the media. Regarding access to justice and specialized services, the mechanism recommends to count with special personnel and agencies to deal with female victims of violence. Regarding budgetary concerns, it recommends to increase public funds earmarked for the aforementioned policies. Finally, the mechanism recommends gathering and disseminating more information on the subject through public service and campaigns. Many Latin American states have instituted public policies on this matter, including the establishment of specialized police bodies, often in charge of women police officers, to protect women and to investigate cases of violence. Also, state agencies or non-governmental organizations have established places to receive women who are victims of violence, providing them with shelter, medical and psychological attention, as well as legal assistance. Thank you for your attention. Please visit our website mookchile.com, and we invite you to watch our next lesson.